Welcome to episode 17 in the first season of Justice Center Weekly, the videocast from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and with me is John Carpay, president and founder of the Center. He's here to give us his reaction to the Ingram ruling, the court case challenging Alberta's lockdown orders, just released on Monday, July 31st. We did a review of the case in last week's episode as we awaited this ruling, which the court had informed us to expect any day. And there it is. Okay, John, react. Victory, defeat, what is it?
Bit of both, bit of victory, bit of defeat. I'm very proud of the fact that the Justice Center was the first organization in Canada to oppose the lockdowns, to call for an end to lockdowns. We did so in May of 2020 when we were barely into the 3.5 years of violations of our rights and freedoms. So when this court action was launched in December of 2020, that was after we had already been suffering 9 months of lockdowns. And I think it was the first court action in Alberta to challenge the lack of medical and scientific basis of lockdowns. And more significantly, the failure of the government to do a proper cost-benefit analysis. Because in fact, the Alberta government, other provincial governments, the federal government, governments can violate our charter rights and freedoms. But one of the things that the government must demonstrate is that those laws that violate our rights and freedoms are actually producing more good than harm. That's a big component of the test, which the courts are supposed to apply rigorously and put the government to the proof of demonstrating with evidence that these charter violating measures are actually doing more good than harm. And so that's something we've not seen in this Ingram decision.
Oh, okay.
But let me start with the positives.
Okay.
We got a ruling from Justice Barbara Romaine, Alberta Court of King's Bench, ruling that the health orders of Alberta's Chief Medical Officer of Health, Dr. Deena Hinshaw, were invalid. And the reasoning was interesting, not because they were unjustified violations of charter freedoms, but rather because Dr. Deena Hinshaw, the Chief Medical Officer, testified at trial that it wasn't really her that was making these rulings to destroy businesses, destroy livelihoods, force people into isolation, prevent families from gathering together for Christmas dinner, keeping children away from school, canceling surgeries, canceling diagnostic services, triggering a new wave of stage 4 advanced incurable cancer. Deena Hinshaw was not responsible for any of this, she said at trial. It was Jason Kenney, the Premier. She was merely advising the Alberta government to do these things, but it was Jason Kenney and the cabinet who were the ultimate decision makers. That was the testimony of Deena Hinshaw at trial. And so the court, following a different ruling that was released a few months back called CM versus Alberta, following a different court ruling, Justice Romaine invalidated Dr. Deena Hinshaw's public health orders on grounds that she, Dr. Hinshaw, should have been the one making the decisions, and the fact that these were actually the decisions of Jason Kenney and the cabinet, that is why they're not valid. So they've been declared invalid, and so that is the victory side of the ruling.
Okay. Yes, as I was, I think, joking to you somewhat sarcastically, I guess that's, we can change our name to the Justice Center for Technicalities.
No.
Because, I'm just kidding. But we take a victory, I guess, where we can get it. It seems strange, that she would invalidate the rulings on this, I guess, kind of slight technicality here. But then in the charter side of it, she said everything was justified. And I thought the charter was kind of like the bigger law of the land, and instead the orders get invalidated on this sort of sub technicality. Anyways, please go ahead with the downside.
So let me just conclude on the upside. There are numerous prosecutions in progress in Alberta. Ty Northcott and his rodeo, the Church of Pastor Tim Stevens, which is Fairview Baptist Church, James Coates and Grace Life Church in Edmonton. Pastor Coates and Pastor Stevens, both people that spent time in jail in the free state of Alberta while the Premier dined at the Sky Palace and broke the COVID rules himself, and then his government was jailing pastors for breaking these rules. So there are these ongoing prosecutions which I anticipate the Crown is going to bring to a halt because you cannot prosecute under a law that is not valid. So this is good not only for Justice Centre clients, but also for many Albertans. I mean, there's all kinds of court cases going on. The Justice Centre is not, is not able to help everybody. So there's lots of people with self-represented or other representation. So I anticipate that all of these outstanding prosecutions are going to come to a grinding halt, which will be good news for people that got, $2,000 fine for being at a peaceful outdoor protest, or people that were violating utterly unscientific rules, like the ban on having Christmas dinner with your mother or with your son, and so that's a very good thing. On the negative side, we have a very troubling statement. You can read this on our website, www.jccf.ca. The judgment is posted there. I'm sure it's also posted in other places. But if you go to paragraph 9 of the ruling of Justice Barbara Romaine, and she says that she is not qualified to assess the scientific evidence, and she says that she's not going to be an armchair epidemiologist, and that she doesn't have the capacity to really assess the government's claim that its measures are scientific. She just not smart enough or not able to really assess the scientific evidence and actually come out with a ruling as to whether the government's claim is true when the government says that these measures are science-based. She says, I'm just not qualified to do that. I'm not going to go there. It's not the court's role to decide which experts are more credible. And then immediately thereafter, she says, but if there is some scientific support for these measures, then the government can just go ahead and violate charter rights and freedoms, and she's going to approve of that. Now, I paraphrased, but go to our website, go to the ruling, paragraph 9, so quite early on. It's a 90-page ruling. This is just appalling that a judge would, on the one hand, contradict herself within a very short paragraph, within 4 sentences. First, she says, I'm not qualified to be an armchair epidemiologist. I'm not qualified to really assess this scientific evidence. And it's not the court's role to really, take a hard look at whether the government's claims are really scientific or not. It's not our job. We can't do it. We're not capable of it. But if the government presents some scientific support, not defined, then she's just going to rubber stamp violation of our charter rights and freedoms. Just appalling.
Yeah, I find that an odd statement too, because she did adjudicate on the qualifications of the expert witnesses. She basically came out and said, well, the government's expert witness, Dr. Kinderchuk, was, reliable and honest, and I believed everything he said. And our expert witness, Dr. Bhattacharya, was not qualified really in the field. So, on weight, she went
through the motions, but it's this repudiates a test which the Supreme Court of Canada laid down in 1986 in a decision called R versus Oakes, O-A-K-E-S, R v. Oakes, and in it there is a test that courts are supposed to use to evaluate charter claims. The test has various components, and the onus is on the government to present compelling evidence to demonstrably justify why it's a good thing to violate, the freedom of expression or the right to bodily autonomy or the right to equality. Any charter right or freedom can be violated by a federal, provincial, municipal government, but the onus is on the government to really demonstrate that that law is doing more good than harm. So towards the end of the judgment, you go to paragraphs 432 or 434 to 441, somewhere around there. We get into this whole big question: did these violations of our charter rights and freedoms? And we did get an acknowledgement. The court held that these lockdown measures did violate our freedoms of conscience and religion and association and peaceful assembly. That was admitted by Alberta. They didn't put up a fight on those fronts. They admitted, yes, these were violations of charter rights and freedoms. But she does not explain. In two sentences, she kind of says, well, I just have the general impression that all these lockdown measures did a lot of good, and they did more good than the harm that was caused. And she says that without looking at unemployment, without looking at mental health damage, without looking at spousal abuse, without looking at child abuse, without looking at children's mental health, children's eating disorders, without looking at drug overdoses, without looking at people whose livelihoods were destroyed. I mean, of course, she's in that lucky public sector category, and her paycheck was not influenced in any way, shape, or form by any of the lockdowns, which cannot be said for a lot of small businesses that were punished and driven into bankruptcy. So she doesn't go through any of that. She doesn't go through physical harms. She doesn't look at canceled surgeries. She doesn't look at all the people now dying of cancer because their fourth stage cancer was not diagnosed in a timely fashion. She doesn't talk about that. She doesn't talk about overall increase in mortality. She doesn't talk about drug overdose deaths, on and on and on and on. There's not a single lockdown harm that she considers, even though there was evidence before her in the report by Dr. Jay Bhattacharya, as well as in Simon Fraser University Professor Douglas Allen did a meta-analysis of lockdowns. And so it's just appalling. She does no review. She just concludes, without any apparent basis, whatever her basis is, she doesn't say what it is. Without any analysis, she just concludes that the lockdowns did more good than harm. And so there we go, the lockdowns were justified.
Yeah, I think she did borrow a bit from the Manitoba ruling as well. At least that was cited, and there was some quoting of that. Yeah, right in the introduction, she says in number 5, however, had the impugned orders been validly enacted by the CMOH, they would not have been, however, are not unconstitutional. While they may have infringed certain of the applicant's rights under the Canadian Charter of Rights and Freedoms, being Schedule B to the Canadian Act 1982 and the Alberta Bill of Rights, these limitations were amply and demonstrably justified as reasonable limits in a free and democratic society pursuant to Section 1 of the Charter, and that they were enacted pursuant to a valid legislative purpose. Okay, now...
So she's referring to a bunch of similar rulings, which I guess... Yeah. Whatever her motivation is for that, I suppose people like to say, well, look at all these other people who are saying the same thing. People like to have that kind of support. But it's the same flawed reasoning in other decisions. The Manitoba decision that she refers to, the trial judge there ignored significant evidence. He ignored the flawed PCR testing. He ignored the fact that the Manitoba government was caught lying to the people of Manitoba. When they said there were 1,000 COVID cases, the government knew full well that at least 560 of those people did not have COVID. And so you had the Manitoba government repeatedly lying to the people with false claims on these PCR tests. That was ignored. And the reasoning in these decisions is that the government is entitled to once the government declares that there is a public health emergency, well, you just accept that at face value. There's no analysis in any of these decisions about the years of life lost and global impact on total population mortality. There's none of that analysis. They're based on the flawed fear-mongering that was started in March of 2020, that COVID is the worst thing since the Spanish flu of 1918, which, by the way, is not true, because we had the Asian flu of 1957 and we had the Hong Kong flu of 1968, and the COVID numbers are very close to those 1957, 1968 flu years. They're far closer to that than they are to the Spanish flu of 1918. And yet you've got the trial judge in Manitoba ranting and raving about how this is the worst pandemic in a century, completely ignoring the facts of what went on in 1957 and 1968. And this very fear-based belief in whatever the government says. And then taking that as a fact, accepting at face value the government's claim that there is this very scary virus that's as deadly as the Spanish flu of 1918. The judges then go on to say, well, in a time of crisis like that, you can't nitpick, you can't quibble, you just have to defer to government. Mm-hmm. And that's the reasoning. That's the reasoning in a nutshell, is if the government declares that there's a medical emergency, then the government can do whatever it wants, and the courts are going to step back and basically turn themselves into rubber stamps, which is what we've seen in this decision as well, but for the fact that this judge did not appreciate Premier Jason Kenney being the prime decision maker. She would have wanted Deena Hinshaw to be the prime decision maker.
Yes, and then we would have had a whole different situation. I mean, one of the things that I found sort of encouraging, it came from a headline in the Western Standard, and that was an article quoting Leighton Gray. And essentially it said, Calgary lawyer expects flood of lawsuits after judge throws out Hinshaw's orders. And I thought, okay, well, that sounds like a victory to me. If people can sue and get some compensation for, their what they lost in these impugned orders. So, I mean, it does sound like a victory in that sense. I mean, but of course, we have the judge supporting medical tyranny, which is the defeat. And I think some people online that I saw in comments that I was reading under various articles were saying that this was the most depressing thing about it, was the fact that, the courts are standing up for, medical tyranny, and they fear this for the future.
Which is why I think the Alberta government now has an opportunity to step in and make some changes to the Public Health Act, because it seems that thus far Canadians are not going to be getting a lot of help from the courts in defending their constitutional freedoms, defending their human rights, defending their civil liberties from authoritarian politicians like Jason Kenney and like Deena Hinshaw, who effectively operates as a politician more so than as a medical doctor. But the Alberta government can and should amend the Public Health Act to build in some protections for rights and freedoms. And I can outline a few of those points if you like.
Sure, yeah. Well, one thing I want to know is, should they clarify who's in charge? That was the thing, right? It seemed like all the politicians, not just the Alberta government, but all politicians, including the federal government, like to point at the doctors running the situation. Oh, we're just following those guys over there, right? We're just following what they tell us to do, and it's their decision. And now when it came down to it in the Deena Hinshaw situation, she said, no, it wasn't me. It was them over there, So I think that can the Alberta government clarify that for us?
Well, I think democracy becomes dysfunctional if you hand over all power to narrow specialists. You can have a medical doctor who might know a lot about the spread of infectious diseases, but she might not know anything about economics or about human rights or about mental health of people or about the environment or about anything else. And it's just very dangerous. You wouldn't put, would you put the province into the care of one teacher to be an absolute dictator because the teacher knows the best way to get the society educated? Or would you put all power into the hands of one engineer because he or she is going to know how to build the best buildings? The whole idea of democracy is that you can have experts on tap You can go to doctors and teachers and engineers and whatever. You can get expertise, but it's we, the people, that are debating the wisdom or lack of wisdom in laws and proposed laws. And so to give that much power into the hands of an unelected, unaccountable medical dictator, I think is contrary to the Constitution. And I think we're better off with a democracy where we can certainly ask the advice of the Chief Medical Officer of Health, but I think it should be the elected representatives who are accountable to the people that make the decisions. And otherwise, we're into authoritarian technocracy rather than a democracy.
I just want to point out, I guess in a way, the politicians did become accountable because we don't have our premier anymore, the guy that was in charge back then, and both health ministers are gone now too, through elections. So there was some accountability there, and then of course the incoming government got rid of Deena Hinshaw. So I guess we got accountability, and from what I'm understanding you're saying is that we actually got it right here, even though the judge ruled we got it wrong. That this was the way it should have been. The government should have been in charge. Anyways, to your recommendations.
So amongst them, and these will be set out in greater detail in a column published by the Western Standard online that should be up before this video cast comes out. And so a few of them include one, that there has to be a vote of the members of the Legislative Assembly to authorize a declaration of a public health emergency, which is to last only 30 days, can be renewed by subsequent votes. That's one accountability measure. Those votes should take place after full debate, and the Chief Medical Officer of Health needs to post publicly the specific data and information on which she is basing her recommendations. This was not done. In April of 2020, Deena Hinshaw and Jason Kenney released a fear-mongering model predicting that even with lockdown measures in place, 32,000 Albertans were going to die of COVID. Well, here we are 3 years later, and grand total of 5,800 people have died with COVID, not necessarily of it, and it was just outrageous fear-mongering. Well, they've never released, even now, the Alberta government has never said, how did they come up with that number of 32,000? So the Public Health Act needs to be amended to require the Chief Medical Officer to say that, if she's going to put out a model saying that 32,000 people are going to die, that she's required to explain, well, what is that based on specifically? And just reveal your sources. People who love truth, people who believe in science, should not have any qualms whatsoever about posting online what they're basing their assumptions on. We had a similar thing with back in 2020, the government, refusing to state how many cycles they were running the PCR tests at. Well, which is actually determinative. You run the PCR test at 40 cycles, everybody tests positive with COVID. You run it at 20 cycles, very few people test positive with COVID. So why did the government not provide transparency on the number of cycles? So the Public Health Act needs to be amended to require that that the Chief Medical Officer actually post the data on which he or she is relying. We also need an all-party committee of members, elected members of the Legislative Assembly. And again, if you love truth, if you are a fan of science, you have nothing to fear from having the Chief Medical Officer responding to questions from elected members of the legislature who represent the people. And if the science is sound, and if the science is solid, then a tough question is not going to be a problem. It's not going to pose a problem. So there has to be a weekly appearance of the Chief Medical Officer where MLAs of all parties can ask her questions, can request information, can request documents, which she has to provide. So those are some amendments to the Public Health Act. Another one would be to say that the authority of the Chief Medical Officer of Health is limited to quarantining sick people, that she cannot quarantine an entire population. Although there again, there's still going to be a democratic check. The Medical Profession Act needs to be amended to clip the arrogance of the College of Physicians and Surgeons of Alberta, which got into the business of interfering in the doctor